Speaker erred in the ruling or was right in the ruling?
Okay, so what I'm going to say doesn't represent the position of the office, and it's not legal advice. It's just my personal opinion of what the constitutional provisions appear to be saying. And so it doesn't represent the position of my office, and it's not legal advice. Anyone who intends to seek legal advice should consult a lawyer of his choice. I think that the speaker got it wrong. The constitutional provisions that he tried to interpret do not really clearly give him that power to determine that a seat is vacant by reason of the fact that a certain MP or whoever has decided to contest either as an independent candidate or, let's say, on a ticket of another political party. It does not really give him the power to do that. And so right from the word go, I don't agree with the speaker on this issue. And any other speaker who has done this, interpreted the Constitution in this manner, I think got it wrong. And probably the Supreme Court should be the forums to interpret what constitutes leaving, what conduct under Article 97(1) G and H constitutes the event that can trigger the speaker to determine or decide the way he did. So I don't agree with him.
Lawyer, yesterday I listened to the speaker, and before he gave the ruling, he did indicate a caveat that he was only going to interpret 97(1) G and H based on his own understanding of the law, and that he's conferred with the Chief Justice and he doesn't see why he should stand his verdict before the Supreme Court rules. Do you think that this ruling has a certain way of casting a certain slur or disrespecting the jurisdiction of the Supreme Court?
Okay, so let's get to the basics. When the constitutional provision is clear and unambiguous, anybody at all can enforce it. So, for example, when you go to the police station and they say that you should be put before court within 48 hours, that is plain and simple, and it can be enforced by anybody. What the speaker sought to do was to interpret a constitutional provision. If you read the constitutional literature on Article 97, almost all the people who speak about this issue admit to a certain unclarity in the law, a certain ambiguity in the application of the law. And so the speaker could not have interpreted Article 97(1)G and H. He could not have interpreted Article 97(1)G and H. And to the extent that he has done that, his actions can be challenged in the Supreme Court for usurping the jurisdiction of the Supreme Court. I would have preferred, given the circumstances, that the matter would have been referred to the Supreme Court for an interpretation to what really is the scope of Article 97(1) G and H. So
Lawyer,
I don't think that the Speaker of Parliament had the power to interpret the Constitution. What he has done is to interpret what constitutes leave the party. Because if I file nomination forms with the intention to contest elections at a future date, the question is, what if I don't actually go ahead with the elections? Maybe something happens, I pull out. Would that mean that I have left the party? I may still be a card-bearing member of that political party. And so there requires an interpretation to that provision. And it is not within the purview of the Speaker of Parliament to say that filing nomination forms to contest in an election, not on the ticket of the party that you are in right now or representing in Parliament, constitutes an event that should mean that the seat should be declared vacant. And the other question is, were the people affected heard? They were not heard. I don't know. The facts don't say that they had the opportunity to speak to the issue.
So, lawyer, on the point you just ended on, that whether the people who stand accused, the 4 members of parliament, was given. I mean, there's a natural thing in law that you give people the hearing. The speaker did indicate in the ruling that he based on the ruling in consonance with the notice of poll as given by the Electoral Commission. When you flip it, 4 years ago, Michael Quay said that he ruled because of Article 97(1)(g), and also because the MPP, which is the party that sponsored the Member of Parliament for Fomena, had written to him that based on their own internal constitution, when you contest the official candidate of the party, you've taken yourself out of the party. Yesterday, Bagbin also did indicate that the notice of poll for the constituencies places the 3 members of Parliament as independent candidates and the Fomena MP as an MPP candidate. So that notice of poll to him corrects or answers the question of whether they've left their parties or not. Is that sufficient?
We should not interpret the Constitution on the basis of the understanding of a former Speaker of Parliament. I personally do not believe that the arrangement that happened previously was actually correct, and it's for a very simple reason. If you read Article 97(1) and you read it together with the other laws that we know of, the interpreting Article 97(1) on the basis of the fact that a political party's constitutional provision says that you should vacate or you should forfeit your membership cannot be used as a basis to interpret what the Constitution actually says in Article 97(1). And so the precedent by Michael Quay, which appears to be the guiding principle for the current speaker, in itself is problematic. I don't believe that Mr. Speaker Michael Quay got it right on that instance, because you cannot use the MPP constitution. And I've checked. He referred to Article 9 of the MPP constitution, where if you context the candidate of the party when you have been deselected by the party at the primaries, that constitutes a forfeiture of your membership. That may be right for the MPP's constitution, but to interpret the 1992 constitution within the context of the NPP constitution, which is not even a statute of state, is a problem. I think that on that instance, the Speaker, Michael Quay, got it wrong, and that precedent should not be the basis for which anybody would assess the rightness of the decision taken by
Honorable Bagbin. Now, finally, lawyer, finally, if the 4 members of Parliament are said to consult you on what to do, will you tell them to sue? Do they have grounds to sue?
No, I would decline to give a legal advice.
A legal advice on that.
You need to consult a lawyer of their choice. But to the extent that they are not happy about what has happened, and obviously I haven't had the opportunity to speak to any of them, but once you are losing certain rights and privileges as a member of Parliament, and you've lost the opportunity to represent the people who have voted for you, I think that they may have a course of action anywhere in the Ghanaian court, so far as they are minded to sue. Because the people should be represented. And once the people have chosen that they represent them, if a decision has been taken by a speaker and you are not happy about it, within the context of the law, you are entitled to challenge it. So that can be possible. They can't challenge it. But I'm not going to say that they should or they should not. It's a decision they may have to take. If they want to consult, maybe yes, but they have to take that decision independently.
Okay. Lawyer Ebo Dantse Benjamin, thank you so much for your explanations this one. We are grateful.
All right. Thank you so much.
Sure. So